Although this trial had taken place in 1970, which is before the charter, we have confirmed that if the charter was in place during the trial, not only would the decision be the same, but the charter would have backed up this decision even more. Good morning. This is your co-anchor Brian speaking.
And this is your other co-anchor Charles speaking.
Welcome to CB News, where we talk about cases and how actual justice was not achieved. In 1970, there was a case that involved John Wray, where we think actual justice was not achieved.
John Wray, who was charged with non-capital murder, which means the punishment was less severe from capital punishment, which was death.
Mr. Wray had made a statement saying that he had threw the murder weapon into the swamp. Mr. Wray had directed the police as to where the murder weapon was located, and they had found the weapon the next day.
The problem with this case was that after the murder weapon was obtained, the trial judge ruled that the statement signed by the respondent was inadmissible, as it was not voluntary. At the conclusion of the trial, the respondent, Mr. Wray, directed the verdict of not guilty.
The Court of Appeal affirmed the acquittal on the ground that a trial judge in a criminal case has the discretion to reject evidence, even if legally admissible and of substantial weight, if he or she considers that its admission would be unjust or unfair to the accused or calculated to bring the administration of justice into disrepute. So this last part about bringing the administration of justice into disrepute basically means that it allows the public to question the decision made by the trial judge, as well as the Court of Appeals.
The backstory that shows that Mr. Wray had signed the statement involuntarily was that the police used forceful interrogation techniques to get Mr. Wray to sign. On March 23, 1968, Donald Comrie was shot in front of North Service Station. This was heard by a 12-year-old boy related to Donald, John Frisch, who found the body of Donald Comrie and saw a man running away with a rifle, presumably John Wray.
So up next, we have the conversation with John Wray and Inspector Lidstone, which shows John Wray telling Inspector Lidstone where he had hid the weapon. What happened to the gun?
I threw it in the swamp.
Where?
Near a mome.
Will you try and show us the spot?
Yes.
Is there anything else you wish to add to this, John?
Not now, thank you.
If this trial had happened after the Canadian Charter of Rights, the decision would have still been the same, and the Charter would have backed up this decision even more, like said before. According to Section 24, Subsection 2 of the Charter, which states, where in proceedings under Subsection 1, a court concludes that evidence was obtained in a manner that infringed or denied any rights or freedoms guaranteed by this Charter, the evidence shall be excluded if it is established that, having regard to all circumstances, the admission of it in the proceedings would bring the administration of justice into disrepute. In this case, the trial judge did think that the administration of justice will be brought into disrepute if they didn't make this decision.
Do you guys think there were issues in this case, and if so, what?
Well, the major issue that Charles and I thought was wrong was that Mr. Wray was acquitted because the trial judge had made the murder weapon, which was probably the most important piece of proving Mr. Wray guilty, inadmissible.
This decision does not prove justice because the evidence being treated as inadmissible allows Mr. Wray to be acquitted. The inclusion of this evidence would have helped the Crown prove the defendant guilty. What solutions do you guys think can actually bring actual justice to these types of cases where a person is acquitted due to the evidence being made inadmissible?
Well, a solution that Charles and I would like to propose to fix this problem and ensure justice is actually achieved is that the inadmissible evidence should have still been taken into consideration, although it would not be the deciding factor in a trial to determine if the accused would be guilty or not, but would still be a small factor and is taken into consideration. As in the case of Mr. Wray, the decision to make the evidence inadmissible would make the case continue without the identification of a murder weapon, which could be crucial to a decision of a trial, especially in a murder case, where a weapon could be imported.
Another solution that could be possibly done is for the evidence that is taken in this sort of circumstances, where the evidence was taken in a way that is not entirely according to the law, is to let the evidence stay admissible, but make sure the evidence is correct with another investigation, as well as to give reasonable punishment to the people who were involved in getting evidence in this case, the punishment of the police officer involved. This is all we have for this morning's news.
But stay tuned for more.